Welcome to Complying with Anti-Lobbying Rules, What Federal Grantees Need to Know, a webinar presented by ChangeLab Solutions, formerly Public Health Law and Policy. We are excited about today's discussion on complying with new lobbying restrictions for federal grantees. Moderating today's webinar is Maris Ash, Founder and Chief Executive Officer of ChangeLab Solutions. In this capacity, Maris has launched and directs multiple pioneering efforts to improve public health outcomes through the use of law and policy. Under her leadership, ChangeLab Solutions builds the capacity of leaders across the nation to use practical public policy solutions as they address a range of chronic diseases. Maris is a frequent speaker at public health conferences throughout the nation, and she consults with federal and state agencies on how best to incorporate legal and policy tools into groundbreaking public health strategies. Thank you, Maris.
Great. Thank you, Livia. Well, welcome everybody. I'm so glad that we're able to do this webinar for the nation. This is something that's been long coming and on an issue that's caused many of us a fair amount of angst, shall I say, on what does it mean and how do we know if and how to comply with the law. So I'm really glad that we're here today and that we have such a strong panel of legal experts to present information. Let me just say a few more words about ChangeLab Solutions before we jump in. We're dedicated to improving the common good, and that means everyone has safe places to live, to be active, nourishing food, and more opportunities to ensure health at the community and state level. We've changed our name recently. Those of you who know us as Public Health Law and Policy, it's everything that you've always known from us, but we hope a little bit more. And with the name change, we're really aiming at focusing on the social change aspect of our work. There's a concept in the law called the laboratories of democracy where we really test innovation at the state and local level, and that we want to focus on the solutions, practical solutions to help meet the urgent needs of states and localities. And so ChangeLab Solutions is our new name to really portray the work that we're achieving and aim to achieve across the country. Those of you who have been to our trainings before know that we present information, legal information, for educational purposes only. We don't enter into attorney-client relationships, and that's going to be really important as we move forward through this webinar too. I want to give resources where you can get attorney-client information on any detailed questions you might have on complying with Section 503. But ChangeLab Solutions also does not lobby. We're a nonpartisan, nonprofit organization. We educate and inform the public through objective and nonpartisan analysis, study, or research. We don't reflect views on specific legislation. Even though we develop model policies, they're really for local governments, state and local governments, to choose how they want to move forward. So today I want to talk about, for 503, and in advance of this webinar, you've gotten a lot of background reading and materials. We hope people have had a chance to go through the simplified memo from Feldesman and Tucker, which we'll talk more about today, and the really terrific guidance that CDC put out a couple of weeks ago. I want to give a hats off to CDC for really developing something that's very readable and very practical for the nation to follow. So thanks to them for that guidance. All of those resources you're going to be able to find on our website. We provided all sorts of additional background, much more detailed legal analysis, and all of the Office of Management and Budget and General Accounting Office and IRS rules and regulations that we really hope are a resource for the state and local attorneys, attorneys to nonprofit organizations who want to understand more, to give you good guidance. All of that's available on our website, and will stay there, as well as this webinar. But we're hoping that if you need legal technical assistance, you will go to our presenters on the call today, that we are not expecting to do ongoing technical assistance on this issue. We have a chat function on your screen. In this, I would like to encourage you to put in as many questions as you can that you have right now and during this webinar into that chat function. I ask that you do not give us any fact-specific information that you need an attorney-client relationship to answer. We cannot be your attorney of record. We can't answer those kinds of questions. But if you put in general questions, here's a hypothetical. What if County Health Department A and Community Organization B and Legislative Official C, really make it generic. We're going to take all the questions that we get during the webinar today, bundle them into similar questions, and we will commit to you folks that we will answer all of those questions in a second frequently asked questions document that we will put out. You'll all get an email announcement when it's ready. It'll take us a few weeks probably to get that done, but we won't have a chance to answer all the questions today, but we will alive today, but we will get to them in writing over time. So please use that chat function. And then let me also draw your attention to additional resources. Section 503 and federal grants compliance, I've given the contact information for Ted Waters and Susanna Vance, who are the attorneys from Feldesman Tucker, who will be training us today on these issues. And so their contact information is here. It'll come up at the end of this webinar too. And then I think most people are familiar with the Alliance for Justice, which does some excellent information and education for nonprofit organizations that seek to stay in compliance with the IRS rules. And so there's their contact information. They have a new website, in case you haven't seen it, boulderadvocacy.org, and I encourage you to use their resources too. So with no further ado, let's get into the text and the body of our work today. I want to introduce Ted Waters and Susanna Vance. They've come to us highly recommended as through the Feldesman Tucker law firm that for decades has been working on federal compliance issues for the nation. Mr. Waters practices in the area of federal grants, healthcare, corporate law, with specialized experience in cost accounting, audit defense, and administrative law. But most importantly for us, his clients include the National Head Start Association, the National Association of Community Health Centers, and he's been legal counsel to numerous state and local health departments. So he understands our world and understands the federal compliance rules, and he's really the ideal person to have done this analysis and this training for us. And he is joined by Susanna Vance, who's an associate with Feldesman Tucker. She specializes in contracting, regulatory compliance, and reimbursement matters. And so I'm going to turn the webinar over to Ted and Susanna and ask them to take us the next step forward. Thanks, Ted.
Thanks, Maris, and good afternoon, everybody. I'm going to start with some of the basics here. We're going to cover OMB circulars and the lobbying rules. Then we're going to talk about how those rules have been modified by this Section 503, which is Section 503 of the Consolidated Appropriations Act of fiscal year 2012, and then we'll have some questions and answers. It's a very, as I think Maris said earlier, a very ambitious agenda, a lot of information that we're going to put out there. I hope we're going to lower kind of the level of angst out in the field on these issues, but there are a lot of concepts that we're not going to have time to fully explain. If you have some questions about something that we're talking about, please type them in and we'll try to get to them either now or later. But I wanted to start today with the kind of long-standing rules about federal grants. And what I like to start with in any grant training we do, and we do a lot of them, is where do the rules come from? And it's particularly important in today's discussion because in every federal grant program, and some of you may know this, most people don't, there's something like over 1,000 federal grant programs funding some $550 billion plus a year out of the federal government to mostly the state governments that are then sub-granted or passed down to local governments and community-based organizations and so on and so forth, but a huge amount of money through all these programs. And it's really, grants are in many ways the fundamental tool that the federal government uses in order to effectuate public policy in this country. And so you have to start, and every single grant program starts, and I'm going to use these check marks, with an authorizing statute. And that authorizing statute says we're going to have a grant program, and it really is much different, by the way, than federal contracts, money to build a new aircraft carrier. There's no special legislation to say, you Navy, go out and build an aircraft carrier. But for grants, every single one of these 1,000 programs has some authorization from Congress signed by the President through a law. So you have to start anytime you have a grants issue. And lobbying is one of a huge array of grants issues that and I'm sure all of you deal with every day. But you got to say, what does the statute provide? What did Congress want these dollars to do? Who's eligible for services under this? Is it an eligible population? You're providing services to Head Start or health centers and some of these other programs we do a lot with. Who can receive those services? In the case of public health, what are you trying to do with these dollars is laid out in the statute. One program we did some work with a few years ago, the Bioterrorism Hospital Preparedness Program. Well, the point of that funding was to allow hospitals to be prepared for some sort of catastrophic event. Well, so Congress says in the authorizing statute, this is what we're going to do. This is what this program is going to do. The other part of that, though, and why it's so relevant today, is the appropriation statute. So you can have a committee of Congress, the Senate Help Committee, for example, the Health, Education, Labor, and Pensions Committees creates a lot of these programs that we all deal with. They can say, we're going to have this great new program and it's going to do all this great new stuff. But if the appropriators don't put any money into it, then nothing happens. And so what I have here is between the authorizing statute and the appropriation statute, you need those two things to come together to create a federally funded program. But to go back one step, what's unusual and what has been unusual in the last few years with the current administration is there are two signature pieces of legislation that are both an authorizing statute and appropriations, have both authorizing functions and appropriations functions. That's both the Recovery Act, where Congress adopted what the administration was recommending, which is we're going to have billions of dollars to do these various things, and of course health reform, the ACA. And the ACA, even more so than the Recovery Act, there were new programs created, including the Public Health and Prevention Fund, Prevention Public Health Fund, and a whole bunch of other things where programs were created and funded at the same time. And I'm telling you this, one, because we lawyers like to talk about this stuff, but two, because this particular program and the issues that we're dealing with today, the Prevention Public Health Fund, if you pull out the language of Section 503, it says that it applies, and appropriations riders, by the way, almost always, with the only exception that I know of being the thing we're talking about today, appropriations riders attach to the dollars that are being appropriated in that year. So let me just say that again. They attach to the dollars being appropriated that year. So in FY 2012, there were these expanded restrictions on lobbying. There's also a salary cap that were put on all labor HHS grant programs. But that salary cap was a much simpler legal analysis because what it does is it attaches to grants funded out of the FY 2012 appropriation. What whoever came up with these new lobbying restrictions, they clearly wanted not just to have the normal course, which is the appropriations rider attaching to the 2012 dollars. And again, appropriations riders attach to the dollars themselves. They aren't changing the authorizing statute. They're attaching to the dollars. What 503 did was say not only are we going to attach to FY 2012 dollars, but we're also going to attach to the Section 4002 of the ACA, the Accountable Care Act, the Prevention and Public Health Fund. And the way that provision of the ACA and a lot of similar provisions, for example, our health center program got a lot of money for funding expansion, new facilities, and so on and so forth. And that provision was very similar to the Prevention and Public Health Fund, where it said each year, here's how much money is going to go into this fund, and it's going to be transferred from the Treasury to the Secretary of the Department of Health and Human Services. And so what Section 503 did was, with that transfer, we're attaching new restrictions to those dollars, restrictions that weren't in the Accountable Care Act in the first place. And we're going to get to those restrictions in a minute, because that's, I think, why we're all here today. But before we get to that, I do want to talk about the basics. So as I said, there's authorizing statute, appropriations. Together they make a marriage and a federally funded program. What rules apply to those programs? Well, there are a lot of rules that come with that authorizing statute and with the program regulations. Another program we deal with, I think many people on the phone deal with Medicaid, also a huge federal grant program. And all those programs have their own individual restrictions and requirements and so on and so forth, Medicaid having more than anybody else. But they also have, there's a set of what's called the common rules that are issued by the Office of Management and Budget. OMB is the part of the White House, believe it or not, that issues rules about management and budget. The management piece includes the cost principles. Cost principles determine what is an allowable cost. And that's extremely important for today's discussion, because, and it's also important to kind of lower the temperature on this issue. You all, federal grantees, state and locals have one set of cost principles, OMB Circular A87. Nonprofits have another set, OMB Circular A122. College and universities, educational institutions have Circular A21. They all have variations, but the vast majority of those sets of cost principles are the same. And they start with the idea of what's an allowable cost. And again, when you read our memo and you think about these issues and you think about what you're doing and whether Section 503 is really going to have a major impact on you, you've got to think, what are we spending these dollars on? Because first and foremost, I think we all know, but everybody should again recognize, federal grants are cost reimbursement instruments. They pay for the cost, allowable costs, to do things that Congress authorized through that program that we were talking about a minute ago. So you get dollars, or you have the ability to draw down dollars from the federal Treasury effectively and spend it on things that further program purposes, the purposes of the program laid out by Congress, and then you have to meet these additional standards, that the cost is reasonable, which means it's reasonable in amount, it's fair market value, and reasonableness is determined by what at least I call the prudent person standard. If you're spending the money at the time, is that how much a prudent person would have spent on that particular cost? They're ordinary and necessary to achieve the program purposes of that grant program. They are allocable to that grant program, which means they are furthering the purpose of that program. You're acting consistently with your federal and non-federal funding sources, and where lots of grantees get into trouble is adequate documentation, that you've adequately documented. So you're spending money on allowable cost. And here's the thing. there are lots of unallowable costs. It isn't just lobbying. You can't spend money on fancy conventions in Las Vegas with lots of alcohol and all sorts of other things either. So there's always been this set of unallowable costs, one of which is lobbying. And the restrictions on lobbying, long-standing, going back to the 80s, and these issues came up in about 1980 and resulted in a 1984 issuance by OMB, and those are the rules that we have all been living under ever since. So for 20-something years, there have been restrictions on lobbying. Lobbying under the federal cost principles is a pretty straightforward thing. It's an attempt to influence the enactment or defeat of pending or proposed federal or state legislation. So it's federal or state legislation, and we put in colors here, some of the operative terms, federal or state. Lobbying includes communication that's written or oral, where you're advocating for or against a piece of legislation. Again, the focus has always been on legislation on a federal and state level. There are three types of activities that have long been prohibited under the cost principles. Direct lobbying, where you are, and I do want to be clear, these are restrictions on the use of federal funds. They aren't restrictions on you as an entity, you as a state or local or nonprofit or for-profit or whoever, or an individual citizen. They're restrictions on the use of those federal funds. So direct lobbying, where you took federal funds, paid the salary of somebody to come here to Washington, D.C. and lobby Congress, that's unallowable. Grassroots lobbying, where you take federal funds, pay for commercial broadcasts on TV and radio to say, stop this piece of legislation, that's grassroots lobbying, where you're making an appeal to the public saying, hey, stop this piece of legislation. And then legislative liaison activities, where you're preparing for lobbying. You've got the smoke-filled back room where you've got people that are running around and doing everything they need to do behind the scenes to get ready for lobbying. So I think I've covered this. So you're writing a letter to a legislature urging passage or defeat of pending legislation, making phone calls, posting flyers, and so on and so forth. And we say up here unallowable lobbying, but again, it's unallowable use of federal funds for lobbying. I really want to make that clear. There were a couple of exceptions, long-standing exceptions, that are specified in the OMB circulars. One is technical and factual presentations to Congress or state legislature, where you say, here's our research and this is what we've done. Even if there's a recommendation at the end, the last sentence could potentially be advocating for a particular piece of legislation. OMB said that's okay, but it also raises another important point. Most of what you do, and a lot of what Suzanne is going to talk about, isn't lobbying. Education, research, those types of things are not lobbying. Lobbying, again, is advocating for change to the law. And let's see. I want to go through quickly four more points that came from OMB, again, Office of Management and Budget, the White House, in 1984. Again, we're going way back here, but these rules have not really been changed for a long time. But going back to 1984, OMB went through numerous permutations of trying to get out a rule on lobbying and restrictions on lobbying because it raises a lot of constitutional concerns. You still have rights as a corporation, nonprofit or for-profit. You still have rights as citizens to, petition your government and so on and so forth. So the key additional points from OMB that they said way back in 1984, one of which I guess is we're going to say in a minute, has gone out the window, is in 1984 they said we're not going to touch lobbying issues on a local level, because and this is what the quote is, direct quote here, there's no rigorous separation between legislative and executive authority at the local level, and therefore it would be difficult to enforce a rule regarding lobbying getting legislature, lobbying the city council or something at the local level. So they said, we're not going to touch local level lobbying, and that's worked well for, as I said, 20 or 30 years. That's kind of beside the point, because we're going to talk about that 503 in a second. But the other things that OMB said that are still relevant today and are highly important. First, no waiver. You do not waive your rights to petition the U.S. government because you took a grant. There are plenty of cases where entities or Congress has tried to force you to waive rights and so on and so forth, an exception for grant funds, and courts have generally struck those down. So, you're not saying we're not going to petition Congress by accepting a grant. What you are saying is you're not going to use federal funds to do it. So, next point they made very clear. No tainting, which is if you have an employee that lobbies and they spend 10% of their time lobbying, I mean, this would be the purest form of lobbying, calling congressmen and women and saying, please vote for this bill or that bill. It's important to the public health of the country. Does that person have to stay away from all grant-funded activities? And the answer is no. That person needs to keep, and the fundamental piece of documentation, I hope everybody knows that the fundamental piece of documentation to show how personnel is being used on, or the time of personnel is being distributed between various grant-funded activities, between grant and non-grant activities, between indirect and direct cost activities, all those things is through a personal activity report. All the sets of cost principles require a personal activity report if you're distributing your time among various funding activities. So what OMB said is if you keep, and this is the last point here, but also very important, if you keep the right documentation, no special documentation is needed for lobbying, you keep the regular documentation that you need to keep in the regular course of business, the accounting documentation showing how federal funds are being used, and you're fine. Hence the little red stuff here. You can lobby non-federal funds. What Congress has said, don't use our money to lobby. And then as long as you keep the accounting straight, you're fine. And what we've told our clients for years and years and years is, the kind of lobbying you're probably talking about is a very low-cost activity, and as long as you account for the fact that somebody on the job is engaging in lobbying, then you've accounted for their time and a little of their overhead and the piece of paper they're writing a letter on or whatever it is, then you're fine, and you can continue. You can do that. So that's kind of the basics. We usually cover that in about 3 hours, but we're going to keep on rolling here. Section 503, and then I'm going to turn it over. I just wanted to make one point on as we move on to Section 503. Again, this was added through the fiscal year 2012 appropriations bill. It applies to those 2012 dollars, as well as extending beyond the 2012 dollars to the money that's transferred over each year from the Prevention and Public Health Fund. So what the Accountable Care Act said is there's going to be this fund, $500 million the first year, $750 million the second year, $1 billion in 2012, $1.25 billion in 2013, and so on and so forth. And we're attaching these restrictions to those dollars. That's what Congress said. What it does is expand beyond state legislatures and Congress, which has been the long-standing prohibitions by OMB, into state-level administrative actions, so executive orders, regulations, and so on and so on and so on. Anytime you're going to the governor's office and saying, Governor, you should either pass a law, issue a regulation to do some change in the law, that becomes prohibited lobbying under 503. Lobbying at the local level, there's rather confusing. In fact, much of 503 is rather confusing, but the restrictions on the local level most clearly apply to local legislatures, city councils, county commissions, and so on. I do want to make an important point here. On the local level, local government law varies substantially from state to state. It is impossible, therefore, for us to say whether your state, what the rule is in your state, because there is such a variation. That's really why OMB tried to stay away from this issue a long time ago. What is a local legislature or legislative bodies? It could be a zoning commission. It could be all sorts of things, but it really has to be analyzed on that in context of that state law. And then the last piece here, which is 503C, has to do with specific restrictions on legal consumer products, guns, and gun advocacy or promotion of gun control, or restrictions on any legal consumer product. And I do want to be clear that in our opinion, and I was happy to see that CDC agreed with us, or vice versa, that this restriction in C, this gun control and legal consumer products, modifies the restrictions in the first two sections of Section 503. In other words, it doesn't create an independent restriction. It emphasizes that the restrictions on lobbying that are prohibited and has all this, again, fairly confusing language. Those restrictions include legal consumer products and advocacy or promotion of gun control. Again, it's not a standalone prohibition. I think that's a really important point. So some of the things I think from the CDC guidance on allowable costs, to provide an issue brief to a state agency, again, urging state executive or legislative agencies in particular or Congress or local legislatures, urging changes in the law is typically what, and law can be an act of Congress. Law can also be an executive order. Law can also be new regulations, and so on and so forth. So when you're urging changes in the law, that becomes problematic. And with that, I think we'll turn it over to Susanna.
Great. Thank you, Ted. So we thought it would be helpful to, let's see, let me make sure I can control the cursor here. We wanted to talk about how these principles apply in the context of a specific grant program, the Community Transformation Grant Program, which is, of course, administered by the CDC, and I know many of you are very familiar with it. Let's see, Community Transformation Grant Program. Thank you, Maris. Got it now. It's a CDC-administered program, which is also authorized by the Affordable Care Act. And it's interesting to consider how the CTG program interacts with these lobbying restrictions, because the program contemplates that the grantees will communicate with the public about policy issues with the goal of improving health outcomes. Ted mentioned that lobbying you can break it down into two components. There's a direct lobbying concept where a person is making an appeal to a government decision maker to change the law, and then a grassroots lobbying concept where there's an appeal to the general public to contact the government decision maker to ask for a change in the law. But OMB and other federal agencies have been clear that it's not lobbying simply to provide information to the public about a federal program. And the same applies with a grantee. When a grantee is charged with administering a federal program, it's a legitimate informational activity, in the words of the Comptroller General, to talk to the public about that issue. For the Community Transformation Grant Program, under the statute, the grantees submit to the CDC a community transformation plan that discusses the policy, environmental, programmatic, and infrastructure changes that will be needed to effectuate these evidence-based health outcomes. And then there's also a concept of sort of mentoring and grantees that are government entities sharing their experiences and replicating successful models in different jurisdictions. So there's a lot of activity under this grant that will involve communications about policy issues. So the CDC issued a guidance, which Ted mentioned earlier, on June 25th of this year that was really helpful in looking at the practical implications of these lobbying restrictions and how they relate to real-world activities that CDC grantees undertake on a daily basis. And if you have the guidance in front of you, first it summarizes Section 503, and then it has a section for CDC itself, and then for government entity grantees, and then nonprofit grantees, talking about which types of activities are allowable and which aren't. Basically, if you look at the activities that are described as being allowable, there's one subset that just don't relate to policy issues at all, and these are kind of a no-brainer. It is not lobbying to educate the public about personal health choices. So the CDC or a grantee could do an advertisement about the benefits of having routine cancer screenings or the benefits of healthy eating. It's also not lobbying if you're doing what would be lobbying to, when you communicate with a private business, like asking a ballpark not to ban smoking on the premises or to serve healthier snacks. That's not lobbying because there's no government decision maker involved. Then if you're thinking of it as a continuum between communications that have nothing to do with government decision making on one end and pure lobbying on the other, there are some activities that are more in the middle, and those involve talking about policy, but these are not lobbying so long as they don't include a direct appeal to the government decision maker or to the general public to ask for a change in the law. So this would include, for example, a research report on policy alternatives to combat childhood obesity. And if the report looks at the evidence, it can go ahead and make recommendations that might find, for example, that laws requiring a certain amount of physical education in public schools or restrictions on the sale of sugar-sweetened beverages have been helpful in certain jurisdictions. And it's not lobbying as long as there's not a direct appeal to enact a certain kind of legislation or regulation. The same would be true with sharing with the public examples of best practices. For example, a report that might talk about steps taken in several cities in the United States to reduce exposure to secondhand smoke. And even discussing and sharing with the public or with government decision makers models, ordinances or laws that have been enacted in other jurisdictions that have been successful in addressing a health issue, that as long as there's no direct call to implement a change in the law under the CDC's guidance, that too does not rise to the level of lobbying. Ted mentioned that there are differences in the way grantees that are government entities are treated under this appropriations rider and the way grantees that are nonprofit entities are treated. And those differences come into play in the exceptions that are in the statute that basically say, in more complicated words than this, that a government entity grantee can communicate freely, for example, a local government agency can freely talk with the city council of, within its same city about policy issues, and also with other agencies within that same government. However, this provision is worded very vaguely. It refers to basically an exception to the normal lobbying rules, quote, for normal and recognized executive legislative relationships, and then also for participation by agencies or officers of a state, local, or tribal government in the administrative processes within the executive of their own government. So it's complicated language, and it has not actually been interpreted by OMB or the Comptroller General, and it's a bit, frankly, the scope of it is a bit unclear, but it is clear that it was intended to allow government entity grantees to communicate freely within their own government, and just the fact that a local government, for example, works with a significant amount of federal funds, which is a very common situation, shouldn't prevent it from being able to communicate freely within its own government. So this exception applies to, this is as I said, the scope of this exception is not clear from the statute, but we think it's a reasonable interpretation to conclude that if a government entity is subject to these lobbying restrictions because it's a grantee, then if it enters a subrecipient arrangement where it's entrusting to another entity, whether it's nonprofit or government, substantive responsibilities under the grant program, then that subrecipient also is subject to the lobbying rules and also would enjoy the same exceptions. So if a nonprofit is a subrecipient to a government entity grantee, then it also could communicate with the government agencies within the same government, just as the primary grantee itself could. And then the second issue that merits some clarification is how is the same government defined? For example, can a county agency benefit from this exception when it wants to address policy issues with a local city council within the county? There it's really a question of how state law defines these governments and what the normal, and the statute refers to normal and recognized relationships, and so just what normal relationships have been established through practice and also under state law. So just to review these exceptions quickly, here are some examples of activities that, and the heading says these are allowable. Really, these are types of activities that fall outside the scope of unallowable lobbying. So the first one is a nonprofit grantee that accepts an invitation from a city council to present research findings on a smoke-free ordinance in the locality. Well, it's clear from the OMB guidance that when a grantee receives a documented request from a government entity to provide testimony or other information to the government entity, it can do so and even provide recommendations about the issue, and it's not lobbying. The next one is a city health department that is a grantee under a federal program, lobbies the city council to ban the sale of sugar-sweetened beverages in schools. This type of activity, since it involves both city health department and the same city's city council, appears to fall within the legislative executive relationships exception. However, we should point out that the AR-12 CDC document that will be included in funding opportunity announcements interpreting this exception seems to imply that there is sort of a core of lobbying activity that even if it went on between an agency and a legislative body within the same government would still be unallowable lobbying. So these types of activities are probably covered by the exception, but I did want to note that that exception is interpreted somewhat conservatively in the CDC guidance. Which brings us to a few more observations about the guidance, which is a very helpful resource. And it makes clear a few points that are very important to remember. As Ted and I have both mentioned, just there's a wide range of activities that grantees can undertake to promote evidence-based solutions to health issues that are not lobbying because they don't involve a direct appeal to make a change in the law. And then the CDC also clarifies, helpfully we think, that subsection C of the statute, which refers specifically to restrictions on legal consumer products and to tax increases, doesn't seem to substantively expand the statute, but more just to emphasize that those subject matters are covered within it. And then it's worth noting also, as you're likely aware, the CDC has already imposed a restriction on lobbying at the local level in its funding opportunity announcements in previous years. So the fact that Section 503 now applies to local level lobbying is in practice not a change for CDC grantees. Before we go to the Q&A, there are a few points I wanted to highlight for you that we think are not clear from the guidance, and in fact may not be clear, period, just because it's a it's a fairly ambiguous statute. But the first is an observation that CDC makes, which is essentially that the IRS regulations should serve as the sort of the guide for non-government entity grantees when considering whether an activity is lobbying. And we did want to point out that those IRS rules are substantively, in the way they define lobbying, are not identical to the rules that are set forth in the OMB circulars and the appropriations riders, and OMB itself has indicated that the rules are not on all fours with each other, and they serve different purposes in a sense, because the IRS rules are only to determine how much of a certain lobbying activity can be conducted without an organization losing its tax exemption. So while those are a helpful reference, they're certainly not determinative. The next issue relates to subcontractors and subrecipients, and I've mentioned that a bit earlier, so perhaps I'll skip over it and we can discuss it in the Q&A if there's more interest in talking about it. And then the last point, I think Ted has really covered this as well, is the guidance makes reference to the fact that grantees can lobby if they segregate federal funds from the other financial resources, with the other resources being used for lobbying. It's just important to note that there is no actual requirement of segregating funds in terms of using separate bank accounts or something like that. There's no heightened requirement of documentation to prove that grant funds weren't used for lobbying. Grantees simply need to follow the rules set forth regarding allowable costs and cost accounting as they would with any other category of costs. So that concludes our presentation, and we'd like to move on to a Q&A session.
Hi. Well, thank you. This is Maris. We have gotten a number of questions that have come in through the chat function, and I just want to encourage folks to write all of your questions in that chat function. Make them hypothetical. Don't give me specific facts in any particular community that would require, a confidential relationship with an attorney, but make them hypotheticals, and we'll group them and answer all of them as much as we possibly can. We'll take a few of them right now, but look for a second. Already you've gotten in advance a frequently asked questions where we put out some typical hypotheticals that we know go on at the state and local level, and we'll add on to those hypotheticals and get them out to everyone. But let me ask a couple of questions that have come in already. What's the legal significance of the guidance document that CDC issued in June? Is it what you might call a safe harbor, meaning that if we rely on it, we know that we're correctly following the law? I think, if I could just add on to this, I think a lot of communities have been kind of surprised that they thought they were following the law when they were doing their CPPW projects, only to find that they were threatened with potential lawsuits of having, fraud against the federal government or something like this. There was quite a lot of shockwaves that went through our community a few months back. And what kind of confidence can federal grantees have now with the CDC guidance that came out, that they're following the law? Ted or Susanna?
This is Ted. That's a very complicated question, and it really depends on a lot of factors. I think in general you can absolutely rely on that guidance. The cases we've had actually are on the other shoes on the other foot, where a federal agency has issued guidance that our clients think are contrary to the provisions of their the law making up that grant, the authorizing statute and the regulations. Generally, a federal agency is going to be bound to follow that guidance, not take contrary positions, but that guidance has to be consistent with the law that makes up that grant program. These letters about threatening lawsuits and so on and so forth, that is a whole another level, which is not, and we were talking about this before the call today, when you have an issue with a federal grant program, the sanction that usually occurs, and sanction is probably not even the right word, is what happens is the government says, to an auditor or whoever, you spent the money on the wrong thing and we want it back. That's a cost disallowance. Or you really have not been meeting the programmatic requirements, so we're going to terminate your grant. When you get into these threats of false claims and so on and so forth, and I'll go out on a limb, we don't want to, lawyers can't make guarantees, but having federal guidance that you follow, does that completely undermine any False Claims Act case saying that you essentially defrauded the federal government? I think the answer is absolutely it does. You can't. You're doing what the federal agency told you to do, and now it would be flabbergasting for any court to say, oh, and that you've somehow misled the government. And that's the heart of any fraud case, is that you misled the government. And that's when you're following the federal guidance, I think you pretty much have complete protection to that kind of allegation.
Great, thank you. I think that's probably given a sigh of relief around the country. Here's another question that's come in. I guess in some communities, many communities work with local coalitions to do their work. And what happens if there's an elected official as a member of the coalition? And is that in the conversation of the coalition? Does that mean that they're lobbying because there's an elected official as a member? How does that work?
It's interesting. That's a great question. I don't know if anybody's familiar with community action agencies and the Community Service Block Grant Program that goes back, it was the heart of the Johnson Great Society programs. They are required by law to have a third of their board, their governing board, has to be elected officials. And the incorporation of various members of a community into a coalition or consortium is a common model, not just in community action agencies or public health, but across the grant spectrum. So, and I don't think any of this touches or makes illegal those or unallowable those types of activities. What this appropriations rider gets at is using federal grant funds to lobby the legislature. Having an elected official on your governing board or steering committee or any of that stuff isn't lobbying the legislature. It is getting viewpoints from across the spectrum of the community. So I just don't see that as being a problem.
Okay. Here's another question. Does 503 only apply to grants under the Accountable Care Act, or does it impact other federal grant programs too?
Right. That's right. I tried to be clear, but I think I wasn't. 503 applies to the dollars appropriated in fiscal year 2012 and to the public health and prevention, or the Prevention and Public Health Fund under the ACA. So most of its reach would apply to any grant funded, any Department of Health and Human Services grant, NIH, HRSA, ACF, CDC, grants springing out of, if that's not quite the right term, but grants that are obligated, the funding is obligated out of FY 2012 funds, have these lobbying restrictions. So it attaches to the appropriate dollars appropriated in the FY 2012 appropriation. And what happens with these riders is they're typically copied from year to year by Congress. And the appropriations rider, as I mentioned, goes back all the way to 1980. It has been copied into the Appropriations Act every year since 1980, and this is the first time they've modified it since then. But it attaches to the dollars and effectively modifies what that authorizing statute, the authorizing statute that created this grant program. It's effectively modifying how those dollars can be used in that program for that year.
I have a couple of quick questions, and then I think we have to end for today. But can a local health department ask a county commissioner to designate a special week, such as an infant sleep week, or is that legislation?
Infant sleep week.
Let's say it's a city. I'm not clear from the question. Can a local health department, let's say it's a city health department, ask a county commissioner to designate a special week, such as infant sleep week?
Designating a special week to raise awareness on SIDS and other,
Right.
infant-related issues absolutely is not lobbying. That's saying, here's a public health problem. Here are solutions. Put your baby, I don't remember which way you're supposed to sleep, but that isn't lobbying. If you said, let's have Infant Awareness Week and march on Capitol Hill to change the law to force everybody to do this, that, and the other thing, that's lobbying or grassroots lobbying. But raising public awareness. Yeah.
One last question, just to drive this home. Even though paragraph C says you can't work on legal consumer products like tobacco, alcohol, junk foods, and beverages, it's just that we can't lobby any more than, can you just clarify the difference of paragraph C compared to A and B one last time?
Yep, finishing that thought, Maris. It's just that you can't lobby on tobacco or gun control or something else, just like you couldn't lobby on, decreasing the speed limit and having bigger sidewalks.
So it's no added burden.
No, we think, and CDC the folks that wrote the CDC guidance seem to think the same way, which is that restriction in C, first it modifies, it doesn't create new prohibitions, it modifies or emphasizes, is a better word, what's in the first two parts of the bill, which is what you're not supposed to be doing. But I don't think it adds anything because I think those activities would have been prohibited anyway.
Okay, thank you. Thank you so much to Ted and Susanna. I've put their contact information up on the the slides. There could be very specific questions that you have that you would like some legal advice on to figure out how to work through in your community. I encourage you to contact Ted or Susanna for that advice. It would be on a fee basis, of course, but as you can see, they're 100% familiar with the issue, so it would be a very cost-effective way to move forward, I'm sure. And I just give you the resource for Alliance for Justice 2 on IRS compliance. All of the FAQs, all of the background documents you'll find on ChangeLab Solutions website. This webinar will be on our website after it's edited. Probably we expect it up tomorrow, so soon for free download. And I want to say to everyone, thank you for joining us and have a great rest of your day. Thanks so much. Bye-bye.